Generally in New Mexico, a felony case begins with a filing of charges in either metropolitan or magistrate court. If the district attorney chooses to continue to pursue the charges, they will then present the case for a grand jury. If that happens, you will receive a target letter from the district attorney's office telling you the date and time that your case will be presented to grand jury. In that target letter, it will contain the proposed charges for the grand jury. If you receive a target letter, you should immediately contact an attorney. Oftentimes, we can then speak to the district attorney prior to the grand jury and stop the case in its tracks. We can do that by either negotiating a pre-indictment resolution of the charges or doing investigation into your case and perhaps presenting to the district attorney reasons why the case should not proceed. If the case proceeds to grand jury proceedings in New Mexico are a closed-door proceeding, a secret proceeding. What that means is that you are not allowed to attend the proceedings unless you are going to testify. Even if you testify, you are not allowed to be in the room while the state is presenting their case. The state presents their case typically in the form of the police officer who was the primary investigator in the case. The district attorney will call the police officer, and the police officer will describe his investigation to the grand jury. He can testify to hearsay because the rules of evidence do not apply at grand jury. That means that a complaining witness does not have to be present at grand jury. If you choose to testify at grand jury, your attorney is not allowed to ask you questions. The only person who can ask you questions is the district attorney. Once the case has proceeded as far as a grand jury, it is highly likely that the grand jury will return a true bill and that the case will be indicted. It's very important to have an attorney prior to grand jury, even if you don't plan to testify, because if there is potentially exculpatory evidence which you would like to have presented to the grand jury, your attorney can bring that to the attention of the district attorney and ask that that evidence be presented to the grand jury. If you are indicted, your attorney may also ask the grand jury not to ask for a warrant for your arrest out of grand jury and instead allow you to appear for arraignment on your own recognizance. One of the advantages to hiring our firm prior to your case being indicted by the grand jury is that we will take the case for a lower fee prior to grand jury, and we will try and negotiate the case or get it dismissed before it's indicted. If we are not able to do that, we will take any fee that you have already paid and we will apply it to any future fees. So you have the opportunity to potentially get your case negotiated or dismissed prior to indictment, and if that doesn't happen, you haven't lost out on anything. One of the things I'm particularly good at and I really enjoy is handling these pre-indictment cases. I've had very good results for my clients over the years in being able to get into a case early and resolve them with a successful outcome prior to going to grand jury. If you'd like to talk to me about your pre-indictment case or a target letter that you have received, please fill out an online case evaluation or contact our firm for an appointment.